Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. You know, I've been doing a lot of geeking out, self-geeking out, if you would, thinking about things like, what happens if we treated all other constitutional rights the same way that Second Amendment right is being treated with recent gun control legislation? For example, like you needed to have a license to speak freely or a license to go to church. Imagine if you had to take a competency exam before you voted, which probably would be a good idea, but still unconstitutional. Imagine if you had to have mandatory liability insurance before you could assert your First Amendment right to privacy. It's pretty ridiculous, isn't it? Well, let me tell you something else that's a little ridiculous, right? Imagine if you had to wait a period of time before you could actually assert your right. That's right, I'm talking about statutory waiting periods. And an argument out of a case in New Mexico, a waiting period law that just went into effect. And you're gonna be shocked, but pleasantly surprised at who is heading the charge here. So today, let's get you all educated and let's talk about the only right you have to wait to exercise. Okay, before we get going too far down the road we're going down, proud to announce that this video is, well, before we go there, this is the God's honest truth. I actually found this company on Kickstarter. Contacted my business manager, Alex, and said, Alex, get a hold of these people. I really, really want to talk to them. What am I talking about? I'm talking about PaintCam. Revolutionize your home system with cutting-edge technology. Introducing the ultimate home security system, PaintCam Smart Home Security. Their cutting-edge security system for home provides unparalleled protection, ensuring your family's safety and giving you ultimate peace of mind. PaintCam's advanced technology detects both humans and pets using state-of-the-art facial recognition to distinguish between welcome guests and potential intruders. In the event of an unwanted intrusion, our system springs into action, deploying paintball markers or tear gas to deter the intruder and mark them for easy identification by authorities. I'm not making this stuff up. How cool is that? PaintCam's Eve Smart home security system funded on Kickstarter in less than an hour, and now at 650% funding. It comes with 3 models, Eve, Eve Plus, and of course the Eve Pro, each with unique functionalities. Features include animal pet detection, face recognition, regular, UV, and upcoming pepper gas paintballs, night vision, sound warning, high-resolution camera, and of course, user-controlled autonomous mode. App integration for easy security settings, adding faces, confirming access, and more. Easy installation process. Currently available on Kickstarter, this is important, at 40% off the regular price. Estimated shipping January 25th. Hey, if you don't believe me, check out some of the features they've done with Fox News, Uncrate, and the Washington Times. Listen, this is really absolutely one of the coolest security devices we've ever seen. Check out that link right there for more information. Visit our good friends at paintcam.eu. Okay, what are we talking about today, America? We're actually talking about the case of Orgega v. Grisham. It is filed in the United States District Court for New Mexico. It is a challenge to newly signed New Mexico Statute Section 30-7-7, new mandatory waiting periods for the purchase of firearms, which is a minimum of 7 full days. Okay, so you understand this new law signed by gun-grabbing Governor Michelle Lujan Grisham would now mandate every New Mexico resident to wait 7 full calendar days before they could take receipt of a lawfully purchased firearm, which means if the NICS background check comes back right away, awesome. We'll see you in 7 days. Now, here's what I also want you to be aware of, and this is really important. The plaintiffs here, of course, they're the individual named plaintiffs, Mountain State Legal Foundation, and the NRA, that's right, the National Rifle Association. And many of you have pointed out to me that I am incredibly critical of the NRA. And of course, the reason you point that out is because it is true. However, I have been critical of the NRA when I believe that it is proper to be critical of the NRA. In order to keep credibility, I'm also going to give the NRA a bunch of attaboys when I think that they deserve it, and this is one of those instances. I have said time and time again, I would like to see the NRA get their knuckles bloodied a lot more, like Firearms Policy Coalition, Gun Owners of America, Second Amendment Foundation, National Association for Gun Rights, and here is a classic example of some really good work by the NRA attorneys here. Now, here is how the plaintiffs outline the issues in their opening memorandum. The action challenges the constitutionality of New Mexico Statute Section 30-7-7.3, the unlawful sale of a firearm before required waiting period ends act, or waiting period act, enacted by the legislature of the state of New Mexico and signed into law by Governor Michelle Lujan Grisham on March 4th, 2024. The Waiting Period Act is effective as of May 15, 2024. With limited exceptions, the Waiting Period Act makes it unlawful for any person who sells a firearm to a purchaser to deliver the purchaser's property to them until a minimum of 7 calendar days after the sale has occurred, even if a clean background check comes back immediately. Violation of the Waiting Period Act results in criminal charges being filed against both the seller and the purchaser of the firearm. Because the Waiting Period Act burdens the right to keep and bear arms, and because the government could never meet its burden to establish a historical analog to justify its regulation, it is unconstitutional under the Second Amendment to the United States Constitution, as made applicable to the states by the 14th Amendment. Okay, this is a very straightforward argument. This is an argument that is exclusively under the Second Amendment. Now, as we know, when it comes to trying to justify modern gun regulations, because let us not forget that the first time any state ever even passed anything remotely similar to a waiting period was 1923. I was shocked that it was that early, actually. But then I found out it was the state of California, and I was like, okay, I'm not so shocked anymore. But 1923, California is the first time we saw anything resembling a statutory waiting period. We know under Bruin that you're going to have to justify this through the existence of similar historical analogs, as the plaintiffs point out here. In Bruin, the court held that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulations. Plaintiffs desire to obtain possession of firearms that they have purchased for lawful purposes, including self-defense in their homes. The Waiting Period Act prohibits plaintiffs from doing so without being subjected to an arbitrary, unnecessary, burdensome, and useless delay. Okay, and that's one of the arguments here is, hey, listen, it's not just a delay. It is a delay that cannot be justified in any way, shape, or form. And many of you are like, well, it shouldn't have to be justified because a right delayed is a right denied. Absolutely 100% true. I'm working with what the case is working with here as well. Now, anytime we're dealing with arguments that deal with limitations on the sale of firearms, what the government will always argue is the Second Amendment is not even implicated here because that only protects the right to keep and bear arms. We're talking about the right to acquire arms, and that is not protected by the Second Amendment. A disingenuous argument for sure. Here's how the plaintiffs dealt with it. The right to keep arms necessarily implies the right to obtain arms. After all, keep means to possess or have weapons. By the Waiting Period Act's very terms, it prevents individuals from taking possession of their firearms. Therefore, because the Second Amendment's plain text covers plaintiffs' conduct, i.e. possessing bearable arms, the Constitution presumptively protects that conduct. Plaintiffs have met their burden under Bruin, and the Waiting Period Act is presumptively unconstitutional. Now, of course, Governor Grisham and all of her cronies in the state legislature said that this was all necessary to save lives. I'm sure they provided absolutely zero data to show that waiting periods save lives because they don't, okay? But here's what the plaintiffs pointed out, because if this is all really about saving lives, you sure created an awful lot of exemptions to this law. The fact that the Waiting Period Act contains exceptions for 1, buyers who hold a valid federal firearms license, 2, buyers who have a concealed handgun license, 3, law enforcement agencies, 4, 2 law enforcement officers under certain circumstances, and 5, between immediate family members, demonstrates that there are some classes of purchasers for which New Mexico does not think a 7-day waiting period is necessary. If the waiting period were a true commercial regulation, it would not maintain exceptions based on the category of purchaser. Okay, and careful what you ask for, because if there's ever another version of this statute in New Mexico, you may see all of those exceptions then removed. But because we know that the plain text of the Second Amendment covers this activity, it's about obtaining firearms. You can't keep and bear arms without being able to obtain them. So the Second Amendment's implicated here. Now the state of New Mexico has to come up with historical analogs to justify the existence of these statutory waiting periods. And I point out, this is not unique to the state of New Mexico. There are many, many states, my state included, which have statutory waiting periods regardless of when the background check comes back. But as the plaintiffs here point out, it is impossible for the state to meet its burden because there is no historical tradition of firearms being regulated in this manner, either at the time of our founding and the ratification of the Second Amendment, or during the Reconstruction era and the ratification of the 14th Amendment. In fact, the first waiting period law was not enacted until 1923 and involved a one-day waiting period for handgun sales in California. Under Bruin, analogies from the 1920s are far too late to offer historical analog to the issue of waiting periods. Okay, and then specifically, what is the NRA and all the other plaintiffs asking for in the way of remedies? We know what the problem is. What do we want the solution to be? Remember, you always have to have a remedy in a complaint. What are you asking for? Well, this is what they're asking for. 1, enter a declaratory judgment pursuant to 28 U.S.C. Section 2201 that the Waiting Period Act is unconstitutional on its face and as applied. 2, enter a temporary restraining order in preliminary and permanent injunctive relief enjoining Governor Michelle Lujan Grisham and her officers, agents, and employees, and Attorney General Raul Torres and his officers, agents, and employees from enforcing the Waiting Period Act. 3, award remedies available under 42 U.S.C. Section 1983 and all reasonable attorney fees, costs, and expenses under 42 United States Code Section 1988 or any other applicable law, and grant any other such and further relief as the court may deem proper. Okay, the case once again is Orgega v. Grisham. We're going to link all of that up below so that you can geek out on it for yourself. Now, as I mentioned, it is the NRA that is leading the charge on this. So I'm going to put a link for them down below so that if you want to show them some love, you will have the ability to do so. By the way, if you have any ideas for videos that we should be doing here at Washington Gun Law, click on that link right there. Some of the best ideas we ever had weren't really our ideas to begin with. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of us. But if you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.